Good evening, and we start with today's lecture on law of sea and maritime law. Today is week 4 and lecture 4, and we start with mainly the maritime law in reference to India. Now, firstly, I would like to refer here what do we mean by the term maritime law. Earlier, we were discussing, or the focus area was on law of sea. Now, the distinction between law of sea and maritime law is that law of sea is based on two countries. Basically, here it is regarding the rights of the two different states, whereas maritime law is with regard to the rights of different parties. That means two different individuals, and this is governed by conventions, different set of conventions. They set the guiding principles for maritime law, or for deciding the disputes that occur in this domain. Now, other important distinctions are like the rights that are decided by UNICLOS. They are in relation to the states, and UNICLOS, in most of the aspects, the provisions of the UNICLOS, they simply govern the rights of the state and very remotely govern the aspects of the ships, except for that UNICLOS talks about the registration of the ship, then how the ship can enter the innocent passage. So that is the aspect. Or you can say the jurisdictional aspect of the ship that is taken into consideration by the UNICLOS. Whereas when we talk about the maritime law, it is more in relation to the commercial aspect of the ships, the kind of commercial rights that we get when we hire the ship, or when someone has taken loan on the ship. So here it creates the values more of economic nature, and there, even if it covers the ship as a property, but it is more in line with the jurisdictional approach when we put the concept of law of sea and we compare, or the ship is covered under the law of sea, and where the ship is covered under the maritime law, it is mainly the commercial aspects that are covered. So in reference to the India, mainly it is the maritime law that deals with the rights that are related to the ship as a property. But in one way or the other, it touches the international aspect. How? Because these laws, the maritime laws, they are either based on international convention, or they are based on the English laws, the British laws that were enacted when the British people were in India, or even if the British people have left. So Indian legislation has adopted many times the English laws. In that respect, there is a strong English connection here. Now we come to what are the key maritime laws in India that will cover different set of rights that are created in different aspects. One is the Merchant Shipping Act 1958, that is the first one. Then is Major Ports Act 2021. Third is Indian Ports Act 1908. Fourth is Admiralty, Jurisdiction and Settlement of Maritime Claims Act 2017. Then is Marine Insurance Act 1963. After that is Multimodal Transportation of Goods Act 1993. Arbitration and Conciliation Act 1996. The Commercial Courts Act 2015 and Carriage of Goods Act by Sea Act 1925. So these are the key maritime laws, but they are not exhaustive. In addition to these listed, there can be further legislation or different set of rules created that are governing or that are regulating the rights of the parties when they are using the ship for the purpose of transportation, or they have hired the ship for one reason or the other. Now we start with maritime law. In India, as elsewhere in the world, is a wide-ranging branch of international law. Basically, this is also the part of international law, and the maritime law is part of both public international law and private international law. Private international law in the sense because it is more dealing with the rights of individuals or the individual parties, and those individual parties mainly belonging to two different nationalities. Whereas the law of sea, that is mainly within the domain of public international law, reason being because that talks about the rights of the states. So here that is the distinction. One by and large falls under the private international law, and the other one, that is the law of sea, that falls under the public international law. Now, when we talk about the different set of rights that are created, assuming that ship is a property and that property is created by the fiction of law, that means just like the company law here, the ship is also given the juristic legal status. That means after it is registered, then it acquires the legal status. There can be mortgage on the ship, there can be loan, or different set of rights can be created assuming that ship is a property belonging to someone. Now, what can be the nature of rights? Like, it includes ship financing, it includes maritime liens, carriage of goods by sea, marine insurance, laws of ownership and registration of ships, ship sale and building contracts, limitation of liability, ship mortgages, manning of boats, the law of collisions, salvage, towage and pilotage, claims and priority of the same, the law of marine pollution, as well as customs and port laws. So these are set of different kind of rights that are created when we assume law as when we assume ship as the property. All these aspects are covered by several pieces of legislation in India, which are based on British legislation on the subjects as applied in India and amended from time to time by the Indian Parliament. So these laws are, as stated to you earlier, that in one way or the other get influenced by the English legislation. Now, one need to know to this fact that these laws, although are motivated by or very much depend upon the English legislation, but that is not the only legislation. English legislation is not the uniformly accepted legislation. So there are two different set of legal stream here. One is followed by the civil law countries. Civil law countries include Germany, France, Italy. Then there are common law countries like Britain, Canada, United States. So these are the common law countries. And we, in reference to India, we being the common law country, belonging to the group of common law countries, we have adopted the English legislation. So in that reference, we are very much connected with the English system. However, there are international conventions with regard to the maritime law. For example, Rotterdam Convention, Hamburg Convention, Hague-Visby rules. So these rules and conventions, they are framed, or the provisions or the key aspect of those conventions are framed keeping in mind the various key features of both common law as well as civil law. So as to create a global impact, or let's say more binding effect of those conventions, for having more binding effect of those conventions, they are not biased, or they are not like unilaterally adopting one mode of legal thinking. For example, Hamburg Convention only accepting the civil law thinking. It's not like that. But those conventions, they are basically the blend of both the civil law system as well as the common law system. Now is the start with Merchant Shipping Act 1958 of India. The principal act dealing with most of the maritime and shipping issues in India is the Merchant Shipping Act 1958. That provides the legislative framework for issues like registration of vessels, seafarers, qualifications, employment, safety wages, collision, pollution rules, salvage, towage, wreck, removal, limitations of liability, passenger claims, etc. So what does the Merchant Shipping Act includes? They are the principal act. That means one of the main frame act in India, dealing with most of the maritime and shipping issues in India. Merchant Shipping Act. The act provides the legislative framework. So basically that is to provide the legal framework for issues like how the ship will be registered, or the vessels will be, registration of the ships or vessels, seafarers, that is those who are taking those ships to different routes, qualifications, should be the qualification for their employment safety, wages, collisions, pollution rules, salvage, towage, wreck, removal, limitations of liability, passenger claims, etc. It may be noted that an attempt to revise the act was made in 2016 by the introduction of Merchant Shipping Bill 2016 on December 16, 2016. So Several times this bill has been amended or new things have been incorporated. Keeping in mind this law should be kept updated with regard to the requirements. So therefore, revision has been made to the earlier law on merchant shipping. But after that, it was referred to the Parliamentary Standing Committee, and the committee in its 249th report in 2017 observed that bill was drafted in a hasty manner, leading to several loopholes and the possibility of multiple interpretations. So this bill, which is referred here, that is Merchant Shipping Bill 2016, that was referred to Parliamentary Standing Committee, and the committee in its 249th report, so while writing the report, observed that bill was drafted in a hasty manner, that it is something that was not hasty here, means not very exhaustively debated, leading to several loopholes and the possibility of multiple interpretations, and there can be multiple interpretations given to the Merchant Shipping Act. That means if we talk about the multiple interpretation, there are two reasons. One is that most of the provisions are open-ended. Open-ended means they are not very strict, and they are subjective in nature, and they may vary from case to case when those cases are brought before the court. So the court may in some case decide in a different manner in comparison to that of the earlier decision by the court in the case of similar nature also, or in the case where it is partly similar and partly dissimilar. So that means it lacks objectivity here. But here I would also like to add, since we need to take the historical perspective that why these bills are loosely framed or they are not strictly codified. Reason being that when the law of sea, mainly maritime law, I would like to add here that mainly when maritime law was framed, it was framed keeping in mind the adverse situation the marine companies are facing or the shipping companies do face. At that time, there was not much advancement of technology, and the shipping business was at great risk. And it was really a very devil work to travel to different places through the sea route. And it was not a matter of surprise that ship getting sunk in a storm or ship getting destroyed in a sea storm. Now, how will those shipping company be able to make the claims, or in case any such party whose goods are loaded in the ship and that ship sunk because of storm in the sea or because of the bad weather or any such natural reasons, but the parties whose goods are lost, they are making the claims, and they are further adding that this was not a seaworthy ship. So in that respect, the shipping company will always be at loss. They will not be able to justify their real position, or they will not be able to get the better defense. So that means they will be out of business. They cannot be in this business, and we cannot expect the transportation being done to far off places through the sea route. So in order to make things more favorable to the shipping companies earlier, and giving them more chance to make the interpretations. So for that reason, these laws were kept as an open-ended provisions and not very strictly codified. And if they are strictly codified, that means it's very probable that rights of the other parties or goods are lost, or the rights of the claimant here, that will be more protected by law rather than the law protecting the shipping company. And that automatically will create an unbalanced situation. So firstly, it was also to create a balanced situation, and also keeping in mind the adversities those shipping companies are facing. They need to bear the losses. So for that reason, it was framed like that. But that it was referred to the Parliamentary Standing Committee, and the committee in its 249th report in 2017 observed that the bill was drafted in a hasty manner, leading to several loopholes and the possibility of multiple interpretation. This was the explanation regarding the multiple interpretation. The committee further recommended a revision of all the different clauses to remove ambiguity, leading to different interpretation and creating loopholes. Next is the Ministry of Ports, Shipping and Waterways in the year 2020 again issued the draft Merchant Shipping Bill 2020 for consideration. So after the earlier bill, 2016 bill, the new bill was presented, that is the Draft Merchant Shipping Bill of 2020, for consideration. It was clarified that the newer bill was drafted with the primary aim of promoting the growth of Indian shipping industry by incorporating the best practices adopted by other advanced countries like the US, Japan, UK, Singapore, and Australia. So now it was to know from others' experience that how the leading nations in maritime law, they have developed their legal framework for maritime law, and how they are practicing it. It's both way, because we simply cannot make the claims based on the subjective interpretation, or make the claims based on the theoretical part. So we need to also test whether practically those theoretical parts are yielding results or not, giving results or not. So here, realizing the experiences that are gained by the United States, Japan, Singapore, these are the leading countries in relation to the admiralty or the use of the ships. So it's not simply that these countries are popular in admiralty, but they also do have the famous shipping companies registered in these countries: Japan, UK, Singapore, Australia, United States. So the world's leading shipping companies are registered in these countries. They are very successful. So the Ministries of Port, Shipping and Waterways in the year 2020 again issued the Draft Merchant Shipping Bill 2020 for consideration. So this was the second time they make changes in the laws in the year 2020, and they have further sent, that means they have delivered it to the delegates or all the representatives for their consideration. It was clarified that the newer bill was drafted with the primary aim of promoting the growth of Indian shipping industry. So at that time, or still today, we need to keep this in mind, that our shipping industry is growing. Not simply that shipping industry is growing, but the trade routes that we follow through the sea routes, some of the trade routes, they are conventional, but we are also exploring the new trade routes. So we need to take things slowly and slowly. Of course, we are also keeping in mind the experiences of the other countries. We are referring to the laws that are belonging to the other countries. But then how those laws will be incorporated in the Indian context, that will be based on the kind of situation we are facing and the kind of realization we attain after those practical experiences. Not simply that we copy it, what is mentioned in the US laws or what is mentioned in the Japanese laws, but whether those laws, or to what extent those laws are viable in the Indian situation and circumstances. So the growth of the Indian shipping industry by incorporating the best practices adopted by other advanced countries like United States, Japan, UK, Singapore and Australia. Presently, the central government, in the exercise of the powers conferred by Section 218A, read with Section 457 of the Merchant Shipping Act 1958, continues to issue new rules for different matters covered by the old Act pending revision. So what happened? The central government, in the exercise of powers conferred by Section 218A, read with Section 457 of Merchant Shipping Act 1958, continues to issue new rules for different matters covered by the old Act pending revision. So they kept on issuing the new rules, despite the fact that old rules were still pending, with a condition for further revision. So instead of waiting that the revision is done, what was the method adopted, that the new rules, they were kept on part and they were made functional. Now with regard to the area that falls both in the context of private international law and also public international law, when we refer here in reference to law of sea, then it is more with the area of international law, public international law. And when we cover the pollution aspect in terms of ships, then it is more in reference to the private international law. So there are two different domains. Part 10B, 10C and 11A of the Merchant Shipping Act 1958 govern civil liability for oil pollution damage, contribution to the International Oil Pollution Compensation Fund, and prevention and containment of pollution of the sea by oil. India has acceded to International Convention on Civil Liability for Oil Pollution Damage 1992 and the International Convention on Establishment of International Fund for Compensation for Oil Pollution Damage 1992. Now, what kind of pollution and how this pollution is created? One is because of the movement of the ships. They do have this diesel engine, so that is one reason. Second is because of the oil spill. That does happen sometime when there is oil leakage, that is known as oil spill. They are carrying in different containers or big containers, so that is one. Second is if the ship has met with an accident, and that is the ship carrying oil, natural, mainly this petroleum or any such hazardous chemical. Okay, why only to confine this debate for chemical oil, or the mainly here oil means the fossil fuel, but also the chemical that is hazardous, and it collided with another ship, or for some reason or the other it broke down, and now it has all spread to the sea waters. So in that reference, what will be the effect? Entire sea water of that closer area will be affected. Have very catastrophic effect to the marine life there, and also in case there are fishermen also passing through those areas, or it can be that there are ports closer to the place where there is an oil spill, or the ship has met with an accident, or ship has sunk, or there is a fire there because of any chemical that ship was carrying. So all that can lead to a very strong kind of, let's say, that can be very catastrophic damage to the environment of that area, to the marine life, to the flora and fauna of that area as well, to the port, I mean here the flora and fauna, to the nearby port as well. Now, another practice that can be the reason for pollution, that near the port facilities, those ships like that carry this fossil fuel in the form of petroleum. So they are sometimes cleaned. That means the empty containers, they are cleaned after multiple uses, and while they are cleaning means they are empty together. For example, let's say India is importing oil from Middle East countries, and through any container, that means container ship, and after multiple voyages, that now container has to be cleaned because maybe it is about to take another kind of cargo. So for cleaning, it will be done near to the port. And what will be the side effect, or what we mean by here the kind of pollution that can be created? The remnants of that petroleum, or whatever is left over in that container belonging to, or that is the leftover petroleum also, or the crude oil. So after this container is cleaned, all that will be thrown in the sea water near to the port, because the cleaning of those kind of containers, the facilities are available near to the ports. So all the vegetation, in case there is a vegetation near the port, or in case there are birds, fishes living, all that certainly will get affected. And many times it has been seen, either they consume that kind of poisonous oil, or they die even. So that is one of the severe consequence of this kind of pollution that is created by our practices or habits. Now, what is the alternate that can be adopted for cleaning those container ships? Now they have taken a different approach. That is, if the container is to be cleaned, or such ship is to be cleaned, then they will bring closer to that ship another container ship, or any such ship that is equipped with machines for cleaning. So that will come closer to the container ship, and the pipes will be fitted, pipes that are actually from the cleaning ship, and those pipes will be fitted to the container ship, and they will automatically clean it, and there will be no such wastage thrown in the water. So all that wastage will be absorbed by the cleaning ship. So in that respect, they have taken the new approach, and we find that is definitely beneficial for the marine life, and other such coastal life. Other relevant legislation in India includes Merchant Shipping Civil Liability for Oil Pollution Damage Rules 2008, Merchant Shipping International Fund for Compensation for Oil Pollution Damage Rules, Merchant Shipping Prevention of Pollution by Garbage from Ships Rules 2009, Merchant Shipping Prevention of Pollution by Oil from Ships Rules 2010, Merchant Shipping Control of Pollution by Noxious Substances, Noxious Liquid Substance in Bulk Rules 2010, Merchant Shipping Prevention of Pollution by Sewage from Ships Rules 2010, and Merchant Shipping Prevention of Pollution by Harmful Substance Carried by Sea in Packaged Form Rules 2010. So these legislation, they are all in relation to the effect of pollution that is created by the human practices. The human practices of one form or the other, and the wide range of pollution, mainly that is to put check on the practices that are going on and to protect environment conditions of that area and also the marine life. Then is the collusion. So this problem of collusion, it occurs in the place where there is a narrow lane of water. That means mainly either at the transit passage or at the strait area. We have discussed widely the strait. And all this, now you see, talking about the strait, that is in reference to the rights of two coastal states. For example, we talk about the Palk Strait, that is near to the Gulf of Mannar, that is between Sri Lanka and India. So there are two states, the rights belonging to the two states. Now let's say if the ship passes through that strait, and then a ship which is passing through that strait area meets with another ship, and maybe that there is an electricity failure or for some reason the two ships have collided. So here it will be the question of rights, the ownership's right. Like for example, I explain it to you. This is the strait area, and two big ships are passing through this, okay, and they have collided here. So because of this collision, now it will be the question with regard to the ownership of this ship and this ship. Whereas when we talk about the rights in terms of public international law, the jurisdiction or the extent of rights in public international law are only confined to which of the countries, like this is state A and this is state B. To what extent state A does have the right over this water, to what extent the state B has right over this transit area. So that is the only extent. But here, so far as the damage is done to the ship because of the collision, then that will be like the question of rights and obligations between these two parties. As here the ownership of the ship here means that it creates right in rem. Right in rem. So there are two kind of rights, we will discuss that are govern and also that give the leading picture about the ship's juristic personality. So the Merchant Shipping Prevention of Collusion at Sea Regulations 1975, adopt the Convention on International Regulation Prevention Collusions at Sea 1972 and its next year. Now sometime it could be that these collisions are intentional by the parties. So therefore, we need to make these conventions. For now, I thank you for being part of this discussion. We continue further on the law of seas. Thank you very much.